Embedded within the Constitution of India lies a powerful instrument for safeguarding the fundamental rights of its citizens, Article 226. This provision empowers the High Courts of India to issue writs, which are extraordinary judicial remedies to enforce fundamental rights and rectify legal wrongs. Article 226 stands as a testament to the Indian judiciary's commitment to upholding the rule of law and ensuring justice for all. The significance of Article 226 lies in its ability to provide swift and effective relief to individuals whose fundamental rights have been violated. It empowers the High Courts to act as guardians of these rights, preventing their infringement by any authority, including the government itself. The provision serves as a crucial safeguard against arbitrary and unlawful actions that may undermine the very foundation of a democratic society. Article 226 bestows upon High Courts the authority to issue 5 distinct rights. They are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. These writs serve as tools for the High Court to address a wide range of legal issues and provide remedies for various types of grievances. Types of writs. Habeas corpus. This writ is used to secure the release of a person who is being held in illegal detention. It is a fundamental safeguard against arbitrary imprisonment and ensures that the individual's liberty is not unjustly curtailed. Mandamus. This writ is issued to compel a public authority to perform a legal duty that it has failed to discharge. It serves as a means to enforce the performance of public duties and prevent inaction or negligence on the part of public authorities. Prohibition. This writ is used to restrain a lower court or tribunal from exceeding its jurisdiction or acting in a manner that is contrary to the principles of natural justice. It prevents abuse of power and ensures that judicial bodies operate within the confines of their legal authority. Quo warranto. This writ is used to challenge the illegal holding of a public office. It serves to maintain the integrity of public institutions and ensures that individuals hold office only through lawful means. Certiorari. This writ is used to quash or set aside orders or decisions of lower courts or tribunals that are found to be illegal, perverse, or erroneous. It acts as a check on the exercise of judicial power and ensures that decisions are made in accordance with the law. Jurisdiction of High Courts. The jurisdiction of High Courts under Article 226 extend to all territories within their respective jurisdictions. This means that they have the power to issue writs against any person or authority, including the government, within their geographical area, regardless of where the cause of action arises. Comparison with Supreme Court's power under Article 32. While both Articles 226 and Article 32 empower the High Courts and the Supreme Court respectively to issue writs, there exists a subtle distinction between their jurisdictions. Article 32 provides the Supreme Court with original jurisdiction, meaning it can directly entertain writ petitions. In contrast, High Courts exercise their writ jurisdiction under Article 226 as a supervisory power, meaning they can intervene in cases where lower courts or tribunals have made mistakes or acted illegally. Discretionary power. The writ jurisdiction under Article 226 is not absolute. High Courts have the discretion to grant or deny writs taking into account the specific facts and circumstances of each case. This discretionary power ensures that writs are not used indiscriminately and that they are issued only when justice so demands. Instances where discretion can be exercised. High Courts may exercise their discretion to deny a writ in cases where alternative remedies are available. If there are other legal avenues through which the aggrieved party can seek relief, the High Court may decline to issue a writ. Delay or dismissal. If the aggrieved party has unduly delayed in approaching the court, the High Court may exercise its discretion to deny the writ. Public interest. In certain cases, the High Court may consider the broader public interest and deny the writ if granting it would cause harm to public or undermine the administration of justice. Scope of remedies. Article 226 is not limited by the availability of other remedies. This means that even if an aggrieved party has alternative legal recourse, they can still approach the High Court for relief under Article 226. This provision ensures that individuals have access access to a wide range of remedies to protect their rights. Protection beyond government action. The scope of Article 226 extends beyond actions of the government. Writs can also be issued against private entities performing public functions such as universities, hospitals, or service providers. This ensures that even private bodies are held accountable for their actions and are subjected to the same standards of legality and fairness as government agencies. Role in upholding constitutional values. Article 226 plays a pivotal role in upholding the constitutional values enshrined in the Indian Constitution. By providing a mechanism for enforcing fundamental rights and rectifying legal wrongs, it safeguards the principles of justice, equality, and the rule of law. The writ jurisdiction under Article 226 acts as a deterrent against arbitrary actions and ensures that power is exercised within the confines of the Constitution. The practical application of Article 226 is exemplified in a number of landmark cases that have shaped the contours of writ jurisprudence. Let's explore a few notable examples. Rodolph Cello versus State of West Bengal in 1978. This case established the principle that Article 226 can be invoked to protect not only fundamental rights but also other legal rights. Bachchan Singh versus State of Punjab in 1980. This case highlighted the importance of natural justice principles and emphasized the High Court's power to intervene when these principles are violated. Anuradha Bandyopadhyay versus State of West Bengal 1988. This case recognized the right to speedy trial as an integral part of the fundamental right to life and personal liberty. Paschim Bengal Krishak Samiti versus State of West Bengal 1989. This case expanded the scope of public interest litigation, allowing public-spirited individuals to seek relief under Article 226 for the protection of public rights. State of Maharashtra versus Manubhai Patel 1989. This case affirmed the principle that Article 226 can be invoked even when there is no violation of a fundamental right, provided there is a legal injury caused by an administrative action. These cases, along with countless others, demonstrate the far-reaching impact of Article 226 on the Indian landscape. They underscore the provision's effectiveness in safeguarding individual rights, promoting social justice, and upholding the rule of law. Article 226 continues to be at the forefront of legal discourse, with recent cases highlighting its relevance in addressing contemporary challenges. For example, the use of writs under Article 226 has been instrumental in securing environmental protection, ensuring transparency in government decision-making, and safeguarding the rights of marginalized groups. To conclude, Article 226 stands as a testament to the Indian judiciary's commitment to protecting the fundamental rights of Indian citizens and ensuring justice for all. Its wide-ranging power and flexibility have made it an indispensable tool for addressing a vast array of legal issues and safeguarding the principles enshrined in the Constitution. As India's legal landscape continues to evolve, Article 226 remains a cornerstone of the judicial system, ensuring that the rule of law prevails and the rights of individuals are upheld.